All right, my name is Cliff Davis. I'm a shareholder here with Roberts Markel Weinberg Butler Haley PC. I will tell you a little bit about myself. We're going to be talking about the annual meeting today, and I do want to clarify that we're talking about annual meetings for non-condominium associations. So if you are working for a condominium or associated with a condominium, I'm not sure that this will help you, but you're of course welcome to stay on. Again, my name is Cliff Davis. I'm a shareholder here with the firm. I've been doing POA law going into my 26th year, and I have been to more annual meetings than I can remember. And I'm going to give you some information today that hopefully will help you run your annual meeting a little more smoothly and answer some questions you might have. You can type in questions in the chat while we're talking, and at the end, we'll answer as many as we can, time permitting. So these are the things we're going to talk about today: the solicitation of candidates, in-person annual meetings, virtual annual meetings, voting methods, knowing your timeline to get ready for your annual meeting, get your notice out, and talk a little bit about the end about amending your bylaws to hopefully make your annual meetings run a little smoother. So every annual meeting, really typically what happens at your annual meeting is to conduct the election or to have the election. There's typically not much other business that's conducted. I mean, the management company gives a report, the board may give a report. If you're under developer control, there may be a developer report, but the primary purpose is to get owners elected to the board. And that starts with soliciting candidates for the board. And this is the statutes, Texas Property Code, Chapter 209, 00593, that talks about every association with 100 more than 100 lots has to solicit candidates for the board, and it gives you the way that you can do that. You can mail a solicitation notice to each owner. You can post that solicitation notice on your website and send an email blast to everybody who's registered an email, or you can post signs in your common areas and send an email to any owner who has registered their email address. My experience is that most associations don't mail the solicitation, that they use 2 and 3, and a lot of times a combination of 2 and 3 to try to solicit candidates. If you're going to use an absentee ballot voting or electronic voting, you should have each person who submits their name fill out a candidate information sheet or some form with that name, so that you can gather background information on the candidate to share with the owners, to mail to them, to email to them, so that when they do cast their vote absentee ballot or they cast their vote by electronic voting, they know a little bit about the candidate that they're going to be voting on. If your association is less than 100 lots, this statute does not apply, but I still think it's a good idea that you use some reasonable method to give every owner notice that there's an election coming and that they have the right to get their name on the ballot. So you're not required to go through this solicitation process, but it's never a bad idea to show the owners that, hey, we're giving all of you a chance to put your name in the hat if you want to run. We're going to first talk about in-person annual meetings. I'm sure that you've all been to an annual meeting that there maybe has been some contention. It can be contentious for everybody involved: managers, board members, the members. Like I said, typically the business that's being conducted at these annual meetings is the election of directors, approving the meeting minutes from the previous year's annual meeting. And keep in mind that when you approve annual meeting minutes, that is approval that comes from the members and not the board. So when you open the meeting, typically you're going to introduce everybody, confirm that you have quorum if quorum is an issue for the annual meeting. And one of the first things you're going to do is approve the annual meeting minutes from the previous year. And that should come from a motion from the floor, a second from the floor, and then a vote of the owners in attendance. And there's a different process we can talk about for virtual meetings if we get to that. And of course, if you're going to have an election, you got to know who can run for the board, and you do that by looking at your governing documents. Typically, you want to look at your bylaws and maybe your articles of incorporation, or as it's now known, the certificate of formation. And it may say only members of the association can run for the board. And typically a member of the association is someone who has a record ownership, which means their name is on the deed to the property. So if your governing documents say that only members can run for the board, you should run the names of the candidates through your system and see if you show them as an owner of the property. So if you've got that requirement and a spouse whose name is not on the deed to the property, they're not eligible to run for the board if your governing documents require that only members can run for the board. They are not a member, and typically the member is defined, like I said, as somebody who's an owner, which means their name is on the deed to the property. This has caused some problems with associations in the past of when they're not sure who can run for the board. And a lot of times the articles, if you've got an older subdivision, by older I mean probably before 1980, the articles will say that you do not have to be a member to run for the board. And that typically was to cover developer representatives. The developer would name their employees to the board, so they just put in their articles that you do not have to be a member, which means that anybody can run for your board. They don't have to be an owner. So you always want to know who can run for the board. And there may be times for your annual meeting where you are having the owners vote on something like a special assessment vote or a vote on the governing documents. But generally what I see is that the only really orders of business is approving the meeting minutes and then the election. So you always want to provide, of course, a timely annual meeting notice. And the property code sets out the notice requirements for an annual meeting, at least 10 and not more than 60 days prior to the annual meeting. But there's kind of another provision that applies if you're going to have a vote by absentee ballot or electronic voting or a combination of both absentee ballot or electronic voting. We believe the property code says that you've got to give owners 20 days to vote if you're using those voting methods. So if you're going to use absentee ballot or electronic voting, you've got to know that your annual meeting notice is going to have to go out more than 10 days before the meeting, because you've got to give the owners that 20 days to vote. And we're going to talk a little bit more about how to do an election solely by absentee ballot. And there was a recent law change that now allows an association to do an election solely by electronic voting. We'll talk about how to accomplish that and make your meeting run a little smoother as we go forward. And the property code says that this section of the property code supersedes any contrary requirement in your dedicatory instrument. However, we are aware of an appeals court case from a jurisdiction that doesn't include, for example, Harris County, that says that you can't use these alternative forms of voting unless it's in your bylaws. So most bylaws, for years and years, annual meeting elections were held by proxy voting or in-person voting. A few years ago, the legislature allowed for these two other types of voting, absentee ballot and electronic voting. And even though the statute says that you would think would mean you can use this no matter what your bylaws say, there is one appeals court in the state of Texas that said that your bylaws have to authorize you to use absentee ballot and electronic voting. So another provision in the property code is that an association's not required to provide an owner with more than one voting method. And an owner must be allowed to vote by absentee ballot, proxy, or electronic voting. So we interpret this to mean that you only have to give one voting method, but if you only give one voting method, it has to be one of those three: absentee ballot, proxy, or electronic voting. We have generally been recommending to associations to move away from proxy voting, to move away from in-person voting, and to move to absentee ballot and electronic voting. I generally tell associations you should offer both of those. And the reason being is that you may have people in your community that might be elderly, that don't use computers or are uncomfortable with computers. So you want to give them a choice, the absentee ballot choice, where they can just fill out their ballot and send it back to you. But we think that if any of you have done this, you'll find that a election conducted by absentee ballot and electronic voting, where you don't have that election at the meeting, where you're not trying to count proxies, where you're not having voting, you're just announcing election results, your meeting will run a lot smoother. And let's talk about proxies a little bit. Proxies confuse people. They confuse managers, they confuse board members, they confuse owners. I'm sure if you're a manager or maybe a board member too, you've been to a meeting where proxy voting was allowed, and people will show up to the meeting with a proxy in their hand that they filled out. Well, they don't need that there if they're there to vote in person. And I think there's a confusion about exactly what is a proxy. And a proxy is an authorization where you allow a third party to cast your vote. So you're basically assigning your right to vote to a third person. That person is called the proxy holder. So if you come to a meeting where proxy voting is being used, you don't need to be a proxy. You're there. You can vote in person. But again, this is very confusing to owners, the exact purpose of a proxy and what it's for. The other thing to remember is that a proxy is not a ballot and should not be used at one. And this typically comes into play for one type of proxy. There's two types of proxies. A traditional proxy. The traditional proxy is where the owner puts in the name John Doe. John Doe shows up at the meeting and votes however they want. If there's anything to be voted on, the proxy holder, in this case John Doe, would vote however they see fit. The second kind of proxy is called a directed proxy. And that's a proxy that actually has the candidate names on the proxy, and John Doe, the owner, would check next to the three candidates that he wants his proxy holder to vote for. So when the proxy holder shows up at the meeting, the proxy holder is instructed to vote for those three people. That's a directed proxy. But that proxy itself is not a ballot. Again, a proxy is an authorization to a third party to cast your vote. So to do things correct, if you have a directed proxy election, the proxy holder shows up with the directed proxy, you give him a ballot, or him or her a ballot, staple it to that proxy, and then the ballot has to reflect the vote as the owner instructed. So that's how a directed proxy is used. If you're going to use proxies, we generally recommend that you include power of substitution language, which means that if a proxy holder can't attend because they got sick or something comes up, they can actually assign those proxies to another person to come to the meeting and cast the vote, or at least be there for the purposes of quorum if you might have a quorum issue. We also recommend that the proxy include that it can be used at any rescheduling, reconvening, or continuation of the annual meeting. And that language helps when you have an annual meeting, you don't meet the quorum requirement. So you say, we're going to come back in 2 weeks and do this again. So that proxy would be good at that rescheduling of that meeting. So in-person proxy voting. So that, like I said, when you're using these two methods of voting, you give a ballot to the owner when they sign in at the annual meeting. They should not be given ballots beforehand. So if John Doe comes in and he's a property owner, he gets a ballot for his vote. If he's holding 5 proxies, you should give him a ballot for each of those 5 proxies. Now, if he tells you, I'm going to vote all these proxies the same, you can just give him 1 ballot and write 6 on it. 1 vote for his vote, 5 for the 5 proxies he's holding. Staple all of those proxies to the ballot, so that, and the reason for that is in the future, if there's a challenge to the election, you want to have your proxies and your ballots together so that somebody doesn't have to try to rebuild what you did at the annual meeting. If you're allowing proxy voting, the most dangerous part of the meeting is the sign-in. That's where you can lose control of what's happening. You've got 2 or 3 people sitting at a desk. There's 15 or 20 owners in line. Some owners have proxies, some don't. You've got to go slow, and you've got to have control of exactly what's happening at that sign-in desk. If a John Doe comes in and he's got 3 proxies, and one of those is for Jane Smith, on your sign-in sheet, John Doe should go to Jane Smith's name and sign his name as a proxy holder for her. So you want to have a sign-in where Each owner signs in for their name, and they sign their name for any other owner for which they are holding a proxy. I mean, this is a lot of information about proxies, and this is exactly why they're very confusing to everybody. If someone assigns their right to vote or signs a proxy for quorum purposes only, like I said, that person's called the proxy holder. The proxy holder must appear at the meeting. You can't just have a proxy without a person there. So the proxy holder has to be at the meeting to fill out, sign a ballot. And remember, a proxy is not a ballot. If an owner submits a proxy, they assign their right to John Doe, but then the day of the meeting, they say, you know what, I'm going to go and vote myself. They have the right to do that. They have the right to show up and say, I'm going to revoke my proxy. I'm here. I'm going to vote in person. So in that instance, John Doe appears at your desk, sign-in desk, and says, you know what, I signed a proxy to Jane Smith, but I'm here. You've got to find that proxy and write on it, not counted, owner voted in person. You know, you got to keeping control of this meeting at the sign-in desk is the most important thing when you're using proxies. And you'll have that. You'll have people submit a proxy and then they'll show up and want to vote, or you'll have somebody sign 3 or 4 proxies to different people, and they'll come in and you say, wait a minute, he already submitted a proxy. So typically in that instance, if you've got multiple proxies from a person, the one with the most recent date will be the proxy that counts. If there's not a date on any of them, I would reject all of them and write on the proxy. Anytime that you have a proxy that you're not going to count for some reason, and one of those reasons may be the owner showed up, you may have duplicate proxies that are both undated, write directly on that proxy why you are not counting it. That saves a lot of time and confusion in the future if you have to do a recount, or if you have to go back and try to figure out what happened at this annual meeting. If you can look at that proxy and the reason why it wasn't counted is written directly on that proxy. So again, I'm going to suggest it again, is move away from proxies and in-person voting. And as we discuss the benefits of electronic voting and absentee ballot voting, you'll see why. All right, absentee ballots, I think they're much more efficient than in-person proxy voting. Again, like I mentioned, when you solicit candidates, if you're going to use absentee ballots, you should send some kind of form so the candidate can fill out that form. And usually for me, it's a one-pager. If you tell people just send in something about yourself, you might get 5 pages from them. It's usually a one-pager, and you tell them, we're going to send this one page and only this one page. Absentee ballots count toward quorum. Whether or not the owner is actually there, they have to be signed by the owner. There's some statutory language that has to be included on that proxy. It's on this slide. If you see on the right side of this slide, that has to be written on the absentee ballot. And owners and candidates should not be allowed to gather absentee ballots and turn them in. Your meeting notice and the ballot itself should have the instructions on how an absentee ballot must be turned in. And if you do not receive an absentee ballot as instructed, it should not be counted. And the reason for that is because the property code says that no one should be given access to ballots except the vote tabulators. So you can't have a candidate go door to door and gather a bunch of absentee ballots that show how the owner voted. That should not be allowed. And if you get absentee ballots in that manner, you should not count them. And again, same thing as with a proxy. If you're not going to count it, write on the ballot why it's not being counted. So typically, the way to return an absentee ballot will be to mail or deliver it to the property manager, or to email it to the property manager. I'll say fax, but I don't know that anybody uses faxes anymore. So typically it's either mail delivered to the manager or email to the manager, or if you have an on-site office, you might have a ballot box that people can come by your clubhouse or wherever and drop their absentee ballot into that box. And again, if you're not going to have the statutory language, this is one of those instances where the law sometimes doesn't really make sense and it doesn't kind of jive with other laws. The statutory language has a sentence in it that's required on the absentee ballot that says you may submit an absentee ballot and later choose to attend any meeting in person, in which case any in-person vote will prevail. However, as we discussed earlier, you only have to offer one method of voting. And if that method is only absentee ballot voting, there's obviously not going to be any in-person voting at the meeting. So if you're not going to allow in-person voting at the meeting, you still have to put this language on the absentee ballot, but you put a disclaimer. Please note that there will be no in-person voting at the annual meeting. Vote tabulators. Again, like I mentioned, only vote tabulators should see the ballots. I typically recommend that if you have a management company, that they take part in the vote tabulation, because they're going to be the people that really handle all of these documents. So really, they should kind of oversee the vote tabulation. Generally, we recommend that you get at least 2 members, 2 association members, 2 volunteers to actually count the ballots. And they should obviously be somebody who are not related. They're not running for the board. They're not related to anybody running for the board. You know, you want to explain their obligations to them, including the statutory requirement. There's a law in the property code that says that a person who tabulates votes cannot tell another person how someone voted. So you want to get 2 people who, you know, a lot of times you might have 2 factions in the association that are trying to get control of the board. And I don't see a problem with getting one volunteer from each of those factions. Obviously, like I said, somebody who's not running for the board members should not tabulate votes. My recommendation is that board members have nothing to do with the ballots or looking at the votes or anything, and they shouldn't be looking at the votes. So this is a form that we see a lot, and it's something similar to this, or this form itself. It'll say proxy/absentee ballot. If you are using this form, throw it away and do not use it. This is mixing 2 different types of voting concepts that have 2 different really ways that they are used. There shouldn't be a combination proxy absentee ballot. And again, keep in mind that the proxy is when you assign your right to vote to a third party. The absentee ballot is when you cast your vote yourself. An absentee ballot cuts out the need for the middleman, cuts out the need for the proxy holder. So now that absentee ballots are available, I really don't see any good reason why you would ever use a proxy again. Because, you know, with proxies, almost every meeting I've been to where proxies are being used, you hear the same 2 things. Those proxies are forged, or somebody lied to somebody to get their proxy. You know, proxies are problematic. They're confusing. Again, we generally advise move away from proxy voting if you can. Electronic voting. So electronic voting is typically where you have a third party that comes in. You give them your email list. They send an email to every owner and say, you know, the election of directors is happening. Click on this link and vote. And on that link, hopefully you've got the candidate information forms where the people can read about the candidates, and they cast their vote electronically. And that company will send the association a report, and it'll say, here's who this person is, here's who they voted for, here's the tally. This is really what we've seen in the associations that have used this have been a lot more participation, because people can just sit at their computer and vote, and we're getting a lot more turnout voter-wise, a lot more participation in the voting. So I understand a lot of management companies have a component now in their software that allows for electronic voting. I personally generally try to recommend using a third party. A lot of owners may see the management company as the tool of the board, and if you hire a third party, it kind of creates a degree of separation. You know, that in some neighborhoods that might be important, in some it may not, and using the management company's platform may be fine. But I generally, recommend using a third party just for that degree of separation from the management company, from the board. It's an independent party that really doesn't care about what the outcome of this election is. So I think that's always probably a good idea. I've got a note here about amending your bylaws to make your quorum requirements more reasonable for the election. And we'll talk a little bit more about amending the bylaws and some of the things you can do to make things easier a little bit down the road here. The election results, decide beforehand how you're going to announce those results. You know, I have some boards that just announce who the winners are. I have some that want to announce every candidate and how many votes they received. Sometimes this can be embarrassing for someone, but I genuinely believe that the more information, the more transparency, the better. And I try to encourage boards to tell the owners every name, how many votes they all got. In every election we have in this country, who the people are and how many votes they got. I think it just helps with transparency, and maybe you get less questions. If it's a contentious election, you should talk to your attorney and your manager to talk about how are we going to announce these votes? What are we going to do? Have a plan going in and know what you're going to do instead of trying to figure it out right there while it's happening. At the end of an election, every ballot, every proxy, every count sheet, which is what the vote tabulators would count the votes on, should be placed in a manila envelope or any kind of envelope and sealed with tape in front of the tabulators. On the tally sheet, you should have your vote tabulators sign that sheet, print their name and contact information. And once all those documents are sealed up, and that's even including the proxies you didn't count or the ballots you didn't count, which hopefully have the reason why they were not counted written on them. You put all of that into one or two or however many envelopes you need, seal it. Once it's sealed, it should not be opened unless somebody requests a recount of the election. And there's a provision in the property code that talks about how to request a recount of an election. So once you've got that, once the tabulators agree on who the winners are, all that information should be sealed up and nobody can get access. Nobody, including the board, should have access to any of that documentation. We'll talk a little bit about virtual annual meetings. Virtual annual meetings have been around for a while, but during COVID, they really came into play. And we have a lot of associations that have never gone back. They have some of them have their annual meeting in person, some still do it virtually, but I think boards found it to be a lot more efficient and also getting a lot more participation because people don't have to come to the meeting. They can get on their computer and do it from home. So, you've got to ask yourself the questions. Can we do it? Should we do it? What about our bylaws? And, that's the issue I talked about before, is that there's that appeals court case about voting using alternative voting methods, and we'll talk about why that's important. Notice to the owners, how do you vote? And is it really a meeting? And the answer to that is obviously yes. It's authorized by law. You can have your meetings virtually. If you're going to have a virtual meeting, obviously you want to have the technology to have a virtual meeting. And, we're using Teams today. My firm uses Zoom a lot for virtual meetings. There may be some other platforms out there. What I've seen a problem with is I've had some boards that try to do kind of a hybrid where they have part of it virtual and part of it in person. And the issues I've seen with trying to do that is that the technology, the people on the computer can't hear the people talking in person and vice versa. So I typically don't like hybrid meetings unless you have the proper technology so that it's seamless, that everybody can hear everybody at all times. Who will run the meeting if you're holding it virtual? You've got to have somebody who's kind of there watching the technical aspects of the virtual meeting. We have that person here today. Kyle in my office is our IT guru for virtual meetings. He's in the background somewhere in case something goes wrong. And you need to have that person too, who knows how to fix the problems and address any issues that may come up. So virtual meetings, the notice requirement is the exact same, at least 10, not more than 60 days. Got to give 20 days notice. If the election or vote is being taken outside the meeting, you got to know your timeline. What does conducting a virtual meeting look like? It should look just the same. It's just virtual. Be organized, choose the virtual setup that's best for your community. How to handle homeowner forum. So I have a lot of boards that have board meetings and even annual meetings, like I said, virtually. And on the notice, they put a request that if you've got a question, please pre-submit it. And then people submit their written questions, and the first questions they answer in the homeowner forum are usually the pre-submitted questions. Pretty much any virtual technology will also have a platform like a Q&A or a chat, and you can have people type in questions and answer them there. and it's the answering homeowner questions is the same everywhere. I always try to tell boards, if you know the answer to the question, answer it. There's one thing that an owner hates more than anything, is asking a question that the board hems and haws on or doesn't answer. If you know the answer, even if it's the answer that the owner doesn't want to hear, answer the question. But for virtual meetings, you can have people pre-submit. You can have that option of having them type in the question and then answering the question there. Calculating quorum can be a little difficult, but it's still basically the same, as whoever shows up can be counted toward quorum. And again, I'm going to talk about a way where quorum really doesn't become an issue for an annual meeting. Obviously for a board meeting, owner quorum is not an issue ever, unless you've got some odd association that has an owner quorum requirement for a board meeting. Typically for a board meeting, a quorum is a majority of the board. Annual meeting minutes approval. There's a way that we'll talk about to approve annual meetings when you're having a virtual meeting, and you can't really have an in-person vote at a virtual meeting. It's very difficult to do that. So if you're having a virtual annual meeting, it's probably going to mean that you've used absentee ballot voting and electronic voting. And we're going to talk about that a little more in just a second. Board meeting minutes. I've had a lot of boards lately that have stopped approving board meeting minutes at the next board meeting. But in order to get them approved and get them on the association's website and in front of the owners, I've got a lot of them now that are approving board meeting minutes by an email vote within 3 or 4 days after the meeting, or whenever the manager can get them ready and get them in front of the board members. And they're finding it more efficient to get those approved through an email vote, which is perfectly legal, and then post them to the website and not wait until the next month, or if you've got meetings every other month, not wait 2 months to get board meetings approved and put in front of the owners. So know your timeline. This is something that we see a lot, is we get a call from a panicked manager saying, I've got the annual meeting, I've got to schedule it, and I think I'm running out of time. You should know in your bylaws, if they state a month or a day or a month range when the annual meeting must be held, you should know that, obviously, and then prepare accordingly. And it really, when you need to start that process, depends on what voting method you're going to use. If you're using in-person or traditional proxy, we generally recommend that you send your meeting notice, and your solicitation in that case can be in the meeting notice at least 20 days before the annual meeting. You've got to give owners 10 days to respond to the solicitation. And then at the meeting, if you're using in-person and traditional proxy voting, like I said, you would hand out a ballot with the candidate names. And so no one would really know who's running until they come to the meeting. You would hand out that ballot with the names at the meeting. So again, you're not going to send a ballot out prior to the meeting when you're using in-person or traditional proxy. If you're using directed proxy, and remember, directed proxy is when the proxy that includes the candidate names, you've got to start a little bit earlier, because you've got to solicit candidates first, get the names, then prepare the annual meeting notice, the meeting notice and the directed proxy. So you've got to start that process probably at least 30 days before the annual meeting election date. So keep in mind, if you're using these methods of voting, when you probably need to start the process. For absentee ballot and electronic voting, if you're using both or one or the other, generally recommend that you start that process at least 50 days before the meeting. And what that means is at least 50 days before the meeting, you want to solicit candidates. Give them at least 10 days to respond. Generally what I tell associations is, from the time you give the notice, whether it's mailed or e-blasted and put on the website, or e-blasted and put up in the community, is to give people at least 13 days to respond. And then that covers your 10-day notice. So you want to start that solicitation process 50 days before the meeting. You've got the 13 days. Then when you get the candidates back, you prepare all of your documents, your absentee ballot, your meeting notice that will also have on it absentee ballot voting instructions, electronic voting instructions. And that notice and ballot should be sent out at least 25 days before the meeting. Because remember, if you're using these forms of voting, which is a vote outside of a meeting, you've got to give at least 20 days. So you want to get it in the mail 20 days. And I typically recommend that the voting deadline be the day before the annual meeting, 5 p.m. on the day before the annual meeting. You either have to have voted electronically, or your absentee ballot has to have been mailed or delivered or emailed so that's physically received by the association by 5 o'clock the day before the meeting. And then the day of the meeting, one of the things that you include in your meeting notice is a solicitation of vote tabulators. And you look, like I said, for a couple of volunteers at least that can either come to your clubhouse or go to the management company and count the votes the day of the meeting. So if it's absentee ballot voting, obviously they're going to count paper ballots. If it's electronic voting, they're going to look at the report provided by the electronic voting company and confirm what that report says, add any absentee ballot votes to that if you're also using absentee ballot votings, confirm that to the manager. And then at the meeting, all you're doing that night is announcing election results. There's no election at the meeting. There's no ballots being handed out. There's no proxies to deal with. You know, over the years, I've been at some meetings where somebody walks in with 100 proxies, and it can take 2 to 3 hours to deal with going through those proxies. This is one of the reasons why we are generally recommending moving away from from proxy voting and in person, moving to absentee ballot, electronic voting, setting the voting deadline on a date prior to the meeting, and at the meeting, you're just announcing election results. We talked earlier about a recount. So the property code has a specific provision that states that not later after the 15th day, after the later day of the meeting, or when the election results were announced, an owner can submit a request for a recount. And that again just starts a process. And that process is this statute list who can conduct the recount. And so we typically contact one of these people. We have a retired justice of the peach. He's actually a justice of the peace judge, not a justice of the peach judge, that we use a lot to do recounts. He does charge a fee. The person requests the recount has to pay that fee. If the recount changes the results of the election, the association has to reimburse the owner that paid for the fee. If the recount does not change the results of the election, then the owner has to absorb that cost for the recount. So the takeaway is, just know that there is a process. There's a deadline by which you have to request this recount if you want one to be conducted. Now, I've mentioned a few times about amending the bylaws. Like I said, there's a appeals court case out there which we think is wrongly decided based on the language of the statute that says that it supersedes anything. That says that in order to use these alternative forms of voting, it has to be in your bylaws. It's probably a good idea anyway to amend your bylaws and address how elections can be conducted now formally, so that it's in writing, it's in your bylaws for all of your owners to see. One of the things that we put in our amended bylaws is not only how to use these alternative forms of voting, but we also adjust the quorum requirement. And, we typically leave in whatever your standard quorum requirement is, which is probably somewhere between 10% and 25%. However, the language that I add in there is that if you conduct your election by absentee ballot or electronic voting or a combination of absentee electronic voting, the quorum requirement is whoever shows up at the meeting. And that ensures a couple of things. It ensures that you're going to have an election every year. Before these alternative forms of voting came into play, there were some associations that couldn't have an election because they could never meet quorum. So we amend the bylaws to say if there's no vote to be taken at the meeting, and this is whether it's an election or just a member meeting for some other reason, if you're going to have a member meeting and there's no vote to be conducted at that meeting, we change the quorum requirement to it's whoever shows up at the meeting. And it's whoever shows up at the meeting in person, if it's an in-person meeting, or whoever shows up virtually, if it's a virtual meeting. We change the quorum requirement to approve annual meeting minutes at the meeting to the number of people who are there at the meeting for an in-person meeting. If it's a virtual meeting and you need to approve annual meeting minutes, we send the annual meeting minutes out with the notice and tell people, here's the annual meeting minutes from last year. If you have any changes, you need to send them to the manager by a date certain. If you don't, the board's going to approve these as written at the annual meeting. So we try to cover approving the annual meeting minutes in person, approving the annual meeting minutes if it's a virtual meeting, allowing you to have an election every year. It's going to happen if you change your bylaws and you use these other two methods of voting. So we think, again, this can make your meeting, annual meeting, much more efficient. You're not conducting an election if you use absentee ballot and or electronic voting. You're not having to deal with the proxies. You're not having to deal with giving people ballots and having people count them. And it just makes for a much more efficient meeting, so you can concentrate on the other things, and that's giving your reports and addressing owner concerns at the meeting. So have your attorney look at your bylaws to see if you think that can be done. Some bylaws say that the board can amend the bylaws already without a vote of the owners, and even if the bylaws say that they may only be amended by the owners, there's a provision in the Texas Business Organizations Code that arguably stands for the proposition that the board can still amend the bylaws without a vote of the owners. There's a couple of nuances to that you might want to talk over to your attorney. And to be honest, there's kind of a split in the HOA attorney industry on what that statute exactly means. But it is out there, and it is something that you can consider if you want to update your bylaws. If your bylaws have not been updated, I'd say within the last 10 years, and we have some associations and they haven't been updated since the association was started, they need to be updated. There's just been too many changes in the laws, and you can use some of these more efficient ways, put these things in your bylaws, processes and procedures to help you run your association more effectively. I think that is all we have on my speech. I know there's probably some questions. If you wouldn't mind, if you could let us know what you think about the presentation. And I think I might have the opportunity to give ideas on if there's something that we did not cover, and don't have to be annual meeting, just anything. Just let us know how you think we're doing. Okay, let's go to the questions. Do we need to send a copy of the annual meeting minutes to the membership prior to approval? So the first thing I'm going to say for all of these questions is, for any question you have, the first thing you do is look at your governing documents and see what they require. So in this case, if your governing documents say you have to send the annual meeting minutes, the answer is yes. There's nothing in the law that says you have to send the annual meeting minutes prior to approval. For a lot of associations that hold in-person annual meeting minutes, they hand the annual meeting minutes out at the door with the ballots for people to look at and review. And then when it comes time for the motion from the floor to approve those, somebody may say, there's a mistake on here that we need to change, and you can consider and vote on those. The owners can consider and vote on those mistakes. What's the best practice for dealing with a tie? Again, look to your bylaws first. Most bylaws I have seen don't have a tiebreaker in them. The bylaws that I rate have a tiebreaker, and it's one that everybody understands. It's flipping a coin. If it's more than two people that are tied, it's putting their names in a hat or whatever and drawing names. Keep it simple. No reason to make breaking a tie difficult. There may be some bylaws that say if there's a tie, you have to have a runoff election. Unless your governing documents require that, I don't see any reason to do that. It becomes much more complicated, time consuming, and possibly more expensive if you have to recall a meeting to have another election. Let's see. How do you feel about soliciting candidates ahead of the meeting and still taking nominations from the floor the day of the meeting? If that's what you want to do, that's fine. I will tell you that when we amend bylaws, we generally expressly state in the bylaws there are not going to be nominations from the floor. There are not going to be write-in candidates. If you want to run, you've got to submit your name in accordance with the statute. But that doesn't mean that you can't do that. You can if that's what you want. So, if you're doing that, then you're probably talking about an in-person vote and proxy voting at an in-person meeting if you're going to take nominations from the floor. Let's see. Another thing too is a lot of your bylaws have a nominating committee provision in there that says that there has to be a nominating committee and they can nominate candidates. I don't know when the last time I heard of an association having a nominating committee. If you've got that language in your bylaws, you're probably violating it unless you are actually appointing a nominating committee. And nominating committees are no longer needed because every owner has the right to submit their name with the solicitation of candidates. And if they submit their name, you can't keep them off the ballot. Two exceptions, of course. One of those is if the candidate has been convicted of a felony or a crime of moral turpitude, which means a crime involving theft, dishonesty, sex offense. In the last 20 years, they're not eligible to serve on the board. Two persons who live in the same house cannot serve on the board at the same time. Those are really the only disqualifications. You can't stop somebody from running, no matter what your governing documents say, if they owe the association money or if they have a deed restriction violation. You can't disqualify them for anything other than the two that I just mentioned. Let's go down the list more. I believe, Kyle, correct me if I'm wrong, everybody that registered will get a copy of this slideshow?
Yes, they'll get a slideshow certificate and we'll send out the link to the video.
Okay, and the certificates are for credit for?
Right, for CE credit for the CMCA certification for the managers.
How do you handle an unopposed election of the board members? So the property code says that if it's an uncontested election, you don't have to have ballots. What I typically do in that case, especially if it's a situation to where you've solicited candidates, you're not going to allow nominations from the floor or write-in candidates, and you've got 3 positions up and you get 3 people that respond. In the meeting notice itself, obviously you don't have to have an election. So in the meeting notice itself, I put in language that says there were 3 positions up for election for the board in 2025. These 3 persons, and put their names, are the only persons that responded to the solicitation. They will be placed on the board at the annual meeting. And then one of the agenda items is, appointment of 3 names to the board of directors, and you state you can state their terms of what they're going to serve. Some attorneys do an acclamation vote, which that's fine. I don't know that I think it's necessary because that is still an election in effect, and the property code says you don't have to have in effect an election. But that's the way I handle that. Is if you've got equal to or less than, you explain what happened in your notice, and on your agenda item you put this person's being placed on the board because it was uncontested. Back. All right. What if you cannot change amendments at this time due to getting 67% to change? So keep in mind your amendment provision. Bylaws may have a different amendment provision than your declaration, your deed restrictions. So you need to look and see what that amendment provision is. And then if it talks about the owners being able to amend the bylaws and doesn't mention that the board can, that's when you need to contact your attorney and have them give you an opinion on if you think the board could do it under the provision of the Texas Business Business Organizations Code. So that's something really, it's going to be a case-by-case basis on what options you have, depending on the language in your bylaws. And I don't think I mentioned it, but in some articles of incorporation, certificate of formation, it's the same thing. They actually say that only the members can amend the bylaws. And in that case, you've got to follow whatever the provision is. There's no other option for you. You've got to do it. You've got to have a vote of the members and at whatever percentage the bylaws say. So if only the board members show up, they are the quorum for the entire association to then vote again for themselves. Well, if you're voting by absentee ballot or electronic voting, hopefully you've got some votes other than the board members. So that quorum requirement that I'm talking about, where it's whoever shows up is the quorum, is in instance where you're using absentee ballot and electronic voting. And then at the meeting, you're only announcing results. So nobody's voting at the meeting. Those people whoever's going to vote should have voted beforehand. And again, that's something where you would need to have amended your bylaws, or recommended that you amended your bylaws to explain what that procedure is. And again, if you're going to amend your bylaws, You've got to determine how they can be amended, and that might involve talking with your attorney what your options are. This is a long one. We sent out directed proxies. The candidates had to submit their name, but according to our bylaws, people can still submit their names for election to the board up to the date of the annual meeting. People could also write in someone's name on the proxy. So this one's a little complicated. You mentioned in here that your bylaws allow for people to submit their names up to the date of the annual meeting. And your question is whose name should be on the ballot. So in that case, remember the directed proxy is not the ballot, but whoever comes in with that proxy can only vote for who they were instructed to vote for. So if somebody submits their name the day of the meeting and the proxy holder walks in with a directed proxy and says, well, I'd like to vote for them, they can't. They can only vote for who they are instructed to vote for on that directed proxy. So probably the reality of your situation is that if somebody submits their name after your directed proxy goes out, they're probably not going to have a chance of winning because the people are going to sign their proxies. They won't know that person has submitted their name, and their proxy holder is going to have to vote for who's on the directed proxy. It sounds to me like you're a prime candidate for amending your bylaws and cleaning up some of that language. The best first step for updating the outdated bylaws is to look at what your amendment options are. And then, a lot of times I'll get an association that might be from 1978, and they're like, we want to amend our bylaws. And the first thing I tell them is, first I tell them, okay, you can do it. This is what it's going to take, whether it's the board or the owners, but we're not going to try to fix your bylaws because they're so old. It's going to be an entirely new document. And sometimes boards want to see a red line of what your changes are, and a lot of times I tell them there's not going to be a red line. It's going to be a completely new document. I mean, these are so old they can't be redlined and fixed. Does every change need to be vetted by legal prior to proposing a motion to approve the changes? And this is about changes to the bylaws. So, fact of the matter is that most of the important things an association does, meeting notices, election, what type of voting method you can use, it's all dictated by statute. So from time to time, I'll get a board that says, hey, can you review these bylaws that we wrote for us? And my response is typically, look, it's going to cost you more for me to look at what you did than it is for me to just give you an entire new set of bylaws. Because unless, those board members are either attorneys or they're extremely well-versed in the Texas property code, there's probably going to be a lot of things in there that violate the property code. So, if you want to amend your bylaws before board members try to write amendments, you should have a conversation with your attorney first and tell them what you're trying to do and have your attorney advise you. I mean, I can tell you in most cases, I'm going to say, tell me what you're trying to do. And I'll kind of tell you in general what the property code says, but it's probably better if I write it than if you write it. How do you handle it when board wants to approve the budget in the annual meeting? Unless your governing documents require that the budget be approved in the annual meeting, I just don't see any reason why you would do that. The board members are elected to run the association, and again, unless your documents require that the owners approve the budget, that's their job. That's what they're elected to do. If they do a bad job on it, there's going to be an election, and the owners can elect somebody who thinks they're going to do a better job at the budget. The problem with budgets is that owners don't see the bills every month. Most owners don't see the bills every month, don't know what things cost. They always think that you're paying too much for your landscaper because somebody comes and mows their yard for $25. They don't understand that you're picking landscapers that have, a few $1 million in liability insurance and workers' comp and commercial auto liability insurance and things like that. So it seems to me a lot of times that just invites an unnecessary fight that sometimes is based on, a lot of times it's just based on the voters not knowing. And then sometimes it's based because you're always going to have that group of people in your association, and I'm sure you all have them, that just whatever the board says, they say no. So unless you have to have that fight with the owners, I don't even know why you would even do that. Need a motion on how to settle a tie. Really what you need, if you don't have any language, is probably an agreement between the people that are tied. If you try to force something on them and say, this is how we're going to do it, and they don't like it, potentially they could file a lawsuit, say it wasn't fair to them. And, a court's going to just want the easy way out. And they'll say, you need to have another election and let the voters decide and not do a flip of the coin if it's not in your bylaws. So, typically in those situations, I would go to the people who tied for the vote and say, got a tie. Here are some options. What do you want to do? And let them agree on what it is. And if they agree on it and one of them loses, it's going to be a lot harder for them to challenge what happened. If bylaws still require nominations from the floor, I presume we need ballots to be handed out, even if absentee ballots were circulated in advance of the meeting. I think that's right. You still got to have to hand out ballots, and you're still going to have to allow in-person voting. I don't see any other way around that. If you're having nominations from the floor at the meeting, you obviously have to let people vote at the meeting. Can you appoint the management company as the nomination committee in order to be in compliance? I mean, first off, get rid of the nominating committee. I don't know that I would appoint the management company and let them decide who they're going to nominate. If you're going to have that, the board, unless the documents prohibit it, the board should appoint themselves as the nominating committee and nominate some candidates. But again, if we've got more than 100 lots, you can't keep people from running. And that's one of the problems with nominating committees, is that the boards would nominate somebody, but they wouldn't let somebody run, and that would create a problem. So now the law says if you've got more than 100 lots, everybody can run, with the disqualification factors I discussed earlier. How do we verify those who have committed crimes of moral turpitude? Probably the question is, how do we verify who has committed a felony or a crime of moral turpitude? And that's really difficult. So the law says if you're presented with evidence from a government database, I think they call it, that somebody's committed this crime, they're disqualified. I've seen it happen, but it's very rarely that it happens. I do have some associations that do a background check. The problem with that is there's only one type of entity that can really do a true criminal background check, and that is law enforcement. They've got access to databases that no one else has access to. You'll see these services that offer a criminal background check. They're not going to catch everything. They may catch everything, in Harris County. In Harris County, I think you can do a search online with the county clerk's office for criminal stuff. But most of the time this comes into play is when somebody reports them and presents with some evidence that this person has a felony or a crime of moral turpitude in the last 20 years. Let's see what else we got. Got time for, well, maybe one or two more. What statutes? So this is, you stated a person can run for the board if they owe fees. However, can they vote at the meeting? Yes. Nobody can be disqualified from voting for any reason. That's in the property code, and I don't know the section off the top of my head, but the intent of that law was to stop associations from disqualifying voters for any reason at all. If you are an owner, you can vote in the election, whether you owe a ton of money or if you have a deed restriction violation. It's a challenge to get volunteers to be on the board. As a result, can we solicit candidates year-round, or does that have to be tied to the annual meeting? No, I think anytime you've got a vacancy, you can ask people if they want to join and send out something and get names, and the board can look at those names and decide if there's somebody they think would work on the board for them. So you can solicit candidates year-round. For the election, if you have more than 100 lots, you have to solicit candidates, but you can do it anytime. All right, let's do one more. Are there key differences for, I guess it's for condo associations? There are. It's, most of what I've told you does not apply to condos at all. So really, for condo, it really is dependent on what the condo declaration says for meeting notices and how elections are to be handled. All right, one more. This is it. Does every association attorney help write update bylaws, or are there some who specialize in it? I think most HOA attorneys handle updating bylaws. It just depends really on, I go to a lot of meetings for whatever reason, probably more than anybody in my firm, to HOA meetings. And so I've seen almost all of it, but there are times when something happens. And the bylaws that I write that I share with everybody in the firm, if they want them, usually I change them in response to something that's happened at a meeting or some challenge an owner has made to the bylaws. And I just go in and fix the bylaws to try to prevent that in the future if it's an issue that I haven't thought of or no one's ever brought up before. So, I mean, I really just think it comes down to, your best judgment to try to pick a competent attorney that's going to help you write bylaws that will help you run your association more efficiently. That's really, we're a little bit over time already. I want to thank everybody for coming, and keep your eye out for the next webinar, which might be next month or within the next couple months. Thank everybody for coming.